I'm David Sklansky, and I teach at the law school. And Chris Kutz is my colleague at the law school and is a walking advertisement for interdisciplinarity at Berkeley, because he's both a distinguished legal scholar and also a distinguished moral philosopher who's written extensively about the political morality of various forms of government complicity and how to think about morality and politics in modern warfare. Before I turn it over to Chris, can I suggest non-coercively that people move forward? Because I think this will work much better if it winds up being a conversation and not just us speaking to you, and that'll flow more naturally if people are closer in.
I should say our idea was to have a kind of moderated discussion, because this is this area of NSA surveillance and drone killing and so on is not an area in which there's really a lot of expertise. I mean, we're reading the newspapers as fast as you are, and maybe not as fast as you are. And we have thoughts, you have thoughts. There's a lot of debate about what the law means. There's even more debate about what the politics of it all mean, or what the morality of it is. And we thought that our trying to get a discussion going was really the best forum for this, rather than present to you our views on the situation.
Government complicity with the Koch brothers, with their puppet masters. You said government complicity.
I think David was just referring to my academic expertise. I wrote a book called Complicity. So let's maybe begin on with the discussion. So and then I'll introduce David after. We thought I would speak a little bit first, and then David would speak, and we'll sort of open it up to a broader discussion. So we divided this roughly. I'll be the drone guy, and David will be the surveillance guy. But the issues are linked. The poster advertises a discussion of drones abroad and drones at home. And obviously, so far, the issues are very distinct. Thus far, we have an extensive program of drone-based warfare abroad, a program run both through the military, through the Department of Defense, and through the CIA, a program that has operations in Afghanistan and Pakistan, in Yemen, most famously, probably in Mali, perhaps in Somalia, Sudan, a program that has quickly become, for the Obama administration, the preferred method of using force in international affairs. It's a program whose defense is that it allows the United States to assert its self-defense interests, to defend itself against lethal threats in a way that minimizes harm to others, including civilians. The further defense is that it's a program that is carefully managed through discussion, largely within the White House, but within the executive process. So it's a far more carefully scrutinized, far more carefully refined program of extranational killing than the U.S. has deployed before, and it provides an alternative to operations such as ground-based insertion of troops, of soldiers, of special operatives, which pose significant risks both to U.S. military and CIA personnel, as well as more extensive risks to persons on the ground. Now that's the official story. We can take that for what it's worth. It's worth something. There's also another story that I'm sure you're here because you've paid attention to, which is that the drone-based campaign against, in the first instance, people perceived as threats to the United States interests, is one that has resulted in very extensive civilian casualties, in a significant number of mistaken targeted killings, in enormous damage to U.S. prestige and to national interest. By one saying is that every drone strike creates 50 anti-American activists. This is another part of the reality. It's the external reality of the program. There is a fair amount of debate and discussion among legal scholars, both within the government and outside the government, about the limits of the legality under either US domestic law under the Constitution or international law about these programs of targeted killing abroad. I think it's fair to say, at a minimum, that some of the actions of the United States have been consistent with international law. Possibly some of them are consistent with, many of them are consistent with domestic law, which is perhaps less constraining. And I think it's almost certainly true that some of the killings are inconsistent with international law, or violations of international law. And we can talk about some of those legal issues. So far, drones have not come to America in lethal form. Drone-based surveillance has been pursued by a number of local law enforcement agencies, by the Border Patrol along the Mexican border. Some drones are weaponized, but not lethally so. Some drones have been armed with tear gas and with rubber bullets. I don't know of any deployments of those weapons in American space by drones, but drone-based surveillance is coming. States are responding, state legislatures are responding. This is a case in which there's been a general theme of the militarization of American policing, and this is something perhaps David will talk about a bit further. But police departments or law enforcement agencies have been eagerly acquiring either literally military surplus drone hardware, or have been excited by the prospect of engaging in the same sorts of operations with some of the same sorts of advantages that they see in the military, and they've been arming themselves up with drones. They've been eager pursuers of drone-based technology, whereas state legislatures have been reacting to this movement often in attempts to limit the extent of drone-based surveillance and famously with the Rand Paul filibuster, any prospect for lethally armed drones in American space. Now, one of the things that's interested me in looking at the drone situation abroad is the effect not just of the targeted killing, but of the surveillance by drones. That's something I don't have very well-developed thoughts on. It's something I'd be very interested in hearing from you all about it. We don't know a whole lot of what it's like to live under drones in Pakistan, to live or Afghanistan or Yemen. But what we do know, it sounds very scary, that even if you do not regard yourself as a likely target of a lethal strike by a drone, the persistent eye in the sky phenomenon, the buzzing, the feeling of being surveilled with a lethal presence is debilitating in a kind of general way, in an atmospheric way. It makes forms of civil society, meetings for celebration, family celebrations, it makes assemblies of numbers of men targets, whether or not those men are engaged in something that even is, on a second glance, evidence of a threat to United States interests. It makes any assembly of men a potential target. It makes movement outdoors a frightening prospect. It makes people in these countries, according to the reports of people who've interviewed the inhabitants of these areas, it puts people in these countries on the constant defensive. And one of the interesting things, I think, to follow with the deployment of drones in the United States, to the extent it's successful, to the extent law enforcement agencies are successful in creating an atmosphere in which general drone surveillance is tolerated, will be the effects on civil society here. I say interesting, not in a complimentary way, but it will be very striking how Americans respond to drone surveillance, and this is an area I think, again, we might want to take up later, in contrast to how they've largely responded to the reports of NSA surveillance, which is with a great shrug. Drones seem to trigger something in the consciousness. The idea of a robotic eye in the sky seems to trigger something in the consciousness of people that is quite distinct from filtering out your Gmail queries or collecting telephone metadata. And I thought, again, one of the themes we might talk about is that. In one way, I'm very happy about the spread to America of drone surveillance, because it should bring home to us what we're doing abroad, in the same way that a military draft forces everyone to reckon with the costs of war. Domestic deployment of drones forces us to acknowledge the significance of what we've begun to do routinely abroad. And so I have some hopes that there will be deployment and reaction. That seems to me the likeliest way to create an effective politics of resistance. But I think things are in a very uncertain state. There is, as I say, a lot of enthusiasm about drone use by law enforcement, just as there has been at the executive level abroad. And I think we're in a state of flux. Those are my introductory remarks. I'll turn this over to David, who I think has some introductory remarks, and then have a conversation. So David Sklansky is my distinguished colleague at the law school, specialist in criminal procedure and evidence and criminal law, a walking billboard for all the virtues of a public law school that is committed to both creating lawyers, but also creating citizens who reflect critically on the law. And David is the author of many things, but a very important book called Democratic Policing.
Democracy in the Police.
Democracy in the Police. Yeah. Democracy in the Police, on the concept of a police and policing in a democratic society, and how we should think about the role of police from precisely a critical perspective within the law. So I'll turn it over to David now.
So first, I want to thank you all for coming today. I mean, this reminds me why I love Berkeley, that this is the kind of community where we can get people to come on a weekday evening and give up some of their time to talk about an issue that should be of concern to all of us. And I'm really looking forward to having a broad discussion of the questions that are raised by domestic surveillance by the NSA and also by drones. So I'll start what I want to do in my remarks is just try to frame what it seems to me we know and what we don't know about the domestic surveillance being carried out by the NSA, connect it with what we know and don't know about drone use, both abroad and at home, and then offer some tentative thoughts about how we should think as responsible citizens about these issues. So with regard to domestic surveillance, we know that the national security agencies collecting, archiving, and accessing vast amounts of information about internet and telephone communications involving large numbers of US citizens and residents, certainly tens of thousands, probably hundreds of thousands, maybe millions. Much of this activity began in the aftermath of September 11th, 2001, and was authorized by an executive order signed by President Bush, but it continued after President Obama took office in 2008. The surveillance involves a bewildering set of sub-programs that change names and contours over time, so it's a little hard to keep track of them. One of the programs disclosed by the New York Times in 2005 involved surveillance of telephone calls originating overseas from or to persons suspected of having links to terrorist organizations. That was originally called the Terrorist Surveillance Program, but it was superseded in 2007 by something called PRISM, P-R-I-S-M. PRISM also involves the storage of internet communications of unknown numbers of people, tens of thousands or maybe hundreds of thousands. We know that the NSA obtained court orders directing some telecommunication companies to turn over logs of all of the customer calls made through those companies on a daily basis. We know that the NSA operates something called the X-key score system, which allows for rapid examination and data mining of internet communications for all communications with one end in the United States. We know that the NSA has constructed and may have already opened a massive data center in Utah costing $1.5 billion. It's estimated to hold 3 to 12 exabytes of information. An exabyte, as I understand it, is 10 to the 18th bytes. It's a billion gigabytes. An exabyte is about 100,000 times the amount of information contained in all the printed material in the Library of Congress. So this is a big facility. We don't know the full scale. We don't know anything. We have nothing approaching a clear sense of the full scale of the NSA surveillance programs or of the extent of the access that the NSA has been given to the contents of communications as opposed to logs of who called whom when and who emailed whom when. That's because the pleadings, the proceedings, and the court orders for these programs are almost all secret. The court proceedings are held before a special secret court in Washington, D.C. that's filled with judges appointed by the Chief Justice of the United States. And some of those orders are made public, but not most. So there's very little visibility about the contours of the surveillance. There's even less visibility about another form of surveillance that gets less press, but in some ways should be of equal or if not more concern, and that's the use of informants. So one reason why the telecommunications and internet surveillance gets a lot of press is because we do have some rules under the Fourth Amendment that regulate when the police can access communications over internet facilities or over telephone lines, and the administration has had to work around those. But we have virtually no rules that govern the use of the government's recruitment and employment of secret agents of various kinds, let's say undercover police officers or snitches. So we have, in some ways, even less of a sense of the dimensions of the employment of that tactic. So that's domestic, that's surveillance. On the drone side, we know we have no official numbers of the number of people killed by drones. We have some unofficial numbers that suggest that a lot. You know, the unofficial estimates are that U.S. drones have killed 3,000 people in Pakistan since 2004. The unofficial number suggests that drone strikes are down sharply this year. There were 25 attacks in Pakistan this year, down from 46 last year and 117 in 2010. 22 strikes in Yemen this year, down from 42 last year. The reduction is in line with a promise that the president made 6 months ago. He vowed to target drone strikes more carefully. Now the CIA has to show a continuing imminent threat rather than just a significant threat, and the strikes are not to be ordered without, near certainty that civilians will not be harmed. That's the theory. The president also promised 6 months ago to make the drone campaign more transparent, but that really hasn't happened at all. We have no official numbers about drone strikes. All of the numbers are unofficial. They're collected by private groups based on local press accounts. We know, as Chris mentioned, that drone use by domestic law enforcement agencies have been limited so far, but that seems poised to change very dramatically over the next decade, partly because law enforcement agencies really want drones. They're exciting, fun new hardware. And the major limitation on the use of drones at this point is FAA rules. But there's lots of pressure on the FAA to reform its rules, not just from the government, but from private groups that want to use drones. And I also believe that as technology advances, the air safety concerns raised by drones will shrink, because we'll be able to manufacture drones that pose significantly less danger to aircraft. And so the argument for allowing unfettered use of them will grow stronger. So now how do we think about these threats? So this is really where I want to hear from you. But my own view is that the main issues have to do less with privacy than with transparency, and fittingly, given that this is sponsored by the FSM Cafe, with freedom of speech. And the fundamental reason for that, it seems to me, is that privacy protections or legal protections more generally are of very limited utility without transparency about what the government is doing. And conversely, transparency does a lot even without formal legal restrictions. It seems to me that that's the great lesson of the Vietnam era, and it's a lesson that has been taught by more recent events as well. One of the major problems with drones has been how invisible drone operations are to the American public. We don't have foreign correspondents embedded with drones. Actually, we don't have foreign correspondents embedded with lots of military operations at all, for that matter, these days, and that's a problem. I think that's why the video of the Baghdad airstrike that Bradley Manning, now Chelsea Manning, released to WikiLeaks created such a sensation. The American public didn't really have a feel for what an aerial attack looked like in Iraq, in much the same way that it doesn't have a feel for what living under drones looks like. I guess I want to read you a couple of passages about Vietnam because I think they shed light on our current moment. And one is from Neil Sheehan, the reporter who obtained the Pentagon Papers from Daniel Ellsberg. And the other is from David Halberstam, who wrote The Best and the Brightest about our involvement in Vietnam. So what Neil Sheehan wrote after he had examined the Pentagon Papers was that they revealed a centralized state far more powerful than anything else, for whom the enemy is not simply the communists, but everything else, its own press, its own judiciary, its own Congress, foreign and friendly governments. All these are potentially antagonistic. It survived and perpetuated itself, often using the issue of anti-communism as a weapon against the other branches of government and the press. But finally, it doesn't function necessarily for the benefit of the Republic, but rather for its own ends, its own perpetuation. It has its own codes, which are quite different from public codes. Secrecy was a way of protecting itself, not so much from threats by foreign governments, but from detection from its own population on charges of its own competence and wisdom. So the emphasis on protecting itself from competence and wisdom, and not just from charges of illegality, strikes me as really significant. What David Halberstam said about this was that each succeeding administration was careful, he thought, once in office, not to expose the weaknesses of its predecessor. After all, essentially the same people were running the governments. They had continuity to each other, and each succeeding administration found itself faced with virtually the same enemies. Thus, the national security apparatus kept this continuity, and every outgoing president tended to rally to the side of each incumbent president. So I think if you change anti-communism to anti-terrorism, this does a lot to describe our current situation. It's a fact that the people who are running the FBI, the CIA, and the NSA are all people who were in high positions of authority in the intelligence agencies under the Bush administration. There's a great deal of continuity there, and it's not because of a grand conspiracy. It's because when people come into office, they need somebody to run these agencies. And the people with expertise are the people who have been involved with running the agencies. So there is almost inevitably a great deal of continuity, and that does some great things. It allows for institutional memory, but it also leads to a great risk of groupthink and establishment groupthink, and those are in some ways as dangerous as disregard of legal standards. So that's why I think that the real issue here is ensuring transparency. It's why I think Representative Ron Wyden's bill to impose new disclosure requirements on the intelligence agencies is critically important. And I also think that in some ways, making sure that information flows freely outside today is even more important than it used to be, because the internet is an incredibly powerful weapon for amplifying information and passing it along once we get it. Drones are actually an potentially an incredibly useful tool for gathering information. You know, as drones get cheaper, it will become easier for groups interested in monitoring warfare in Pakistan to obtain footage of what's going on, and the government knows this. The main impediments to public understanding of how the drone campaign, say, is operating overseas, as time goes on, will become less technological and more cultural and legal. And that's why I think that we need to keep an eye not just on ensuring transparency, but also on any threats, either legal or cultural, to restraining full discussion and open discussion and open criticism of what our government is doing at home and abroad. So I think I'll stop there, and maybe at this point we can throw it open for discussion.
Sorry, we're recording this. We have this 15 minutes.
That's great.
Thanks very much. And thanks for setting this all up, because I think it is a very important issue. It seemed to me that on September 11th, when the news reported that somebody whispered into George Bush's ear in a little classroom somewhere in the South that America is under attack, that was really the first and biggest mistake that was made. And what flowed from that was the idea that we were going to war with terrorism. And that became a slogan and a metaphor and the law, in essence, because war powers were granted to the president to go after Al-Qaeda as a warrior nation, rather than looking upon it as a criminal act that would have to follow criminal procedures, international or domestic. And Obama campaigned with the idea that he was going to end that concept of us being at war with Al-Qaeda and with the tactic of terrorism, which that was one of the, I think, most attractive things about him as a candidate, because that's obviously what led us down the horrendous path into Iraq and Afghanistan. And we're still there. We're still in Afghanistan. And my feeling is that we need to hold Obama and the Congress to that promise to end this notion that we are at war. And I think what would flow from that is that if they want to search out and seek out miscreants, even worldwide, there are methods for doing that. We have Interpol, we have CIA, we have all of the intelligence services of all of our allies that can help us, and we can help them deal with these problems in a way that does not require or does not allow the executive to just take actions in any country that he sees fit under the notion that we're at war, and that the victims of all this are just the casualties of war. They're combatants. So I think that would be a major first step, would be to go to Congress, go to the president, and say, okay, we've tried the war route. Let's end that, and from here on out, we'll see this for what it really is, which is, it was obviously a horrendous crime what happened on September 11th, but let's deal with it that way.
It's one very striking feature of the politics of this. Obama says the right things. There was a speech, about a month ago, in which he said it's time to move off the war footing, it's time to renormalize. It was a little bit before that he said we had to move the drone killing from the CIA to the Pentagon. Given up on that. We have, in principle, democratic control over intelligence gathering. We have Dianne Feinstein as the chief cheerleader for the NSA. That the ordinary mechanisms, the ordinary mechanisms of democratic politics, the election of a president who was seen as smarter about these things, more refined in his use of national security, the ordinary politics, mechanisms of politics don't seem adequate right now to handle the inertia of the national security state. And I would just add, I mean, that's one reason to wonder whether transparency is quite enough. In a sense, there are disclosures, there are disclosures to democratic channels, but it may be necessary, but I'm not sure it's sufficient.
That's fair. But I think it's really necessary.
Yeah.
Yes, hello there. It's a very interesting panel. Thank you very much for your comments. I think one of the points I just wanted to, and this is in reference to one of the problems with the intelligence gathering aspect of you've mentioned X-Key Score, you've mentioned PRISM, but one of the programs that needs to also be mentioned is that of GCHQ, which is the British use of tempora, which also came out in Snowden's revelations there. And the thing about the tempora program is that it actually bypasses any need for a warrant of any sort. And you know how it does that? It does that by tapping into the transatlantic cables. The British actually are using the 2 stages. The first stage is virtually complete. The second stage, when it is complete, will be able to fill up the equivalent of, you mentioned the Library of Congress before, with the British Library 192 times over every day. So the question then, of course, is how can that be used? But I think the important thing to note is that there should be legal regulations, but unfortunately what tends to happen in intelligence sharing agreements is that the information is tapped into and bypassed. So you actually don't need a warrant. Even, for example, FISA, the Foreign Intelligence Service Act, in a sense, is rendered irrelevant because the information can be gathered via the tempora program as part of a shared agreement. And that's one of the things that has to be dealt with, and I think one of the points maybe you can comment on. And the second point I suppose I just wanted to make was that in terms of drones, how do you sell something? You render it benign. In remote areas of the world where drone technology is being contemplated, for example, in some of the police services in Australia is deciding to use drones. So what do? It's not so much save the kitten, but it's to save the person from a bushfire. So police, we have to keep in mind that what police forces are doing there is to extract the drone from its origins, which is the military-industrial complex, and render it civilian. And that's one of the things perhaps we should consider at that point.
I think that's right, but I think you're absolutely right. We need to think about how we respond to the reality that the intelligence services are going to be getting access to lots of telephonic communications and lots of internet communications. And it's true that we require a warrant for a lot of this stuff in the United States, but it's not clear how much that requirement does, because the warrants are obtained when the government goes to the secret court in secret without anybody arguing on the other side. So I think that there's it's hard to imagine a future in which the government isn't obtaining lots of data on how we're communicating and who we're communicating with. One reason I say that is that you could imagine legal rules that would restrict it, but legal rules have to be applied and interpreted, and legal rules are always subject to new exceptions being created, including secret exceptions being created. So I think that this is going to happen. The intelligence state isn't going away. The military isn't going away. And the problem is that there are predictable and very harmful organizational pathologies that the intelligence agencies and the military and government itself are prone to when left to their own devices. And I think that the best protection we have against those pathologies is access to and publicizing of as much as we can of what goes on. So I think it's among the greatest failings of this administration has been the failure to follow through on promises for transparency. And I mean, this administration has been reluctant not just to disclose what it's doing, but the legal justifications for what it's doing. And I think, I think that if this administration takes that position, it's fair to assume that any administration is going to take that position, and it's just it's an unavoidable fight there, and it's just a fight that we're going to have to wage.
Yeah. A while back, two activists went to work in a slaughterhouse in Iowa, and they filmed animal abuse while they were working there. And it was just recently, they made it illegal for anybody to do that again. Now, with the exposés of Bradley and Snowden, it's almost like the government is trying to make whistleblowing illegal. Maybe you could comment about that.
Well, certain kinds of whistleblowing have always been illegal. The kind of whistleblowing that Private Manning engaged in and the kind of whistleblowing that Edward Snowden engaged in have been illegal for decades. What's changed, I think, is there's been a greater inclination on the part of the government to go after whistleblowers. There have been more leaks prosecutions in the Obama administration than in any other administration. So this is less, I think, an issue of the law on the books and more an issue of the stance that the administration takes towards whistleblowing and leaks. And I don't think that it's a peculiarity of this administration to be to respond more harshly to leaks than previous administrations have done. I think that it reflects in part the increasingly stitched together nature of the globe in the information age. And I think I'd be surprised if succeeding administrations are not similarly inclined as this one has been to try to plug leaks aggressively. And I agree with you that's a problem. And I think there are lots of people in this administration who know better, including the president. But there are institutional pressures and organizational pressures within the government that push away from the direction of transparency. So I think even when you have an administration headed by somebody who is sincerely in favor of transparency, as I believe the president is, unless there's a lot of external pressure, the drift will be away from the direction of transparency.
One of the very striking things for me, one of the surprising things about the Snowden revelations was the revelations of how ill-controlled the security apparatus is by its own internal rules and procedures. And I just saw the New York Times article briefly this morning about the 1,000-page report, or 1,000 pages of documents, I guess, for abuses in 2009 by the NSA of exceeding their mandate given to them by this extremely permissive court, but nonetheless exceeding the mandate in collecting information far beyond the bounds of what they were legally authorized to do. And it surprised me, frankly. I would have thought that these organizations, the NSA, would be fairly disciplined in how they apply their internal procedures, that they would be very scrupulous about whom they hire, about how many people have access to the most sensitive kinds of information, if for no other reason than to prevent Snowden-type revelations. And it is very striking that the mechanisms of internal control seem to be utterly lacking. And it's a reason for thinking that actually protecting whistleblowers who report not their sense of sort of foreign policy mistakes of the United States, but failures of United States agencies to follow their own procedures, that protection for that class of whistleblower seems actually really essential to provide some degree of confidence that the internal procedures are being followed.
I had noticed you'd said that you thought that perhaps tens of thousands or hundreds of thousands of people's actions were being followed or listened to. And so two-part question. I'm wondering if you have other information, because the last 4 or 5 whistleblowers that have come out from the NSA in the last 10 years, the numbers I'm hearing is more like tens of millions or hundreds of millions, and being stored away. All this information is being stored in those massive data centers you mentioned. So that's part one, is do you have information that it's really less than millions? Because that's what I'm hearing. And then the other thing is, I don't know if you saw the story in the New York Times, October 26. I would like your take on what you think about the Department of Justice announcing on the 26th, here it is in the New York Times, that they intend to start utilizing warrantless wiretap information to prosecute a particular defendant. I wonder if you're aware of that and what your thoughts are. The Department of Justice making that statement, they intend to just go ahead and start using warrantless wiretaps.
Well, so I might be misremembering the story, but I thought what they announced was that they would now disclose when they were relying on that information, whereas in the past they had taken the position that they didn't need to disclose it even if they relied on it.
You are right. In fact, the story came out that they went to great lengths to tell those agencies they shared the information with, don't tell anybody this came from an illegal warrantless wiretap. Come up with another way. So yes, now they're coming out and just saying, hey, we're going to use warrantless wiretaps in the case. So yes, it is full disclosure. That's, I guess you could call it a step forward maybe, but it seems a perilous position when with the Constitution and the Bill of Rights and the Fourth Amendment, all this kind of thing, it just seems a little bit of an overreach to just say, yep, we're going to go ahead and dragnet surveil and use what we find.
Well, I think it would be a step forward to have the issues of the legality of the NSA programs litigated in a real court, a court that is publicly accessible, that holds proceedings in public, that allows public access to pleadings, and that makes its rulings public. Because it doesn't surprise me that, that agencies like the NSA and the CIA did a bad job in enforcing their own rules, because it's secret. And I think it's almost, it's very hard for agencies to be as careful as they should be about almost anything if they're not accountable. And being accountable to other parts of the government bureaucracy is a weaker form of accountability than being accountable to the public, because people who are part of the establishment, who go to the same dinner parties, whose kids go to the same schools, who know each other, are less likely to raise hostile and uncomfortable questions than people who aren't part of that circle. So I think it's striking to me that after the Snowden revelations, a number of high government officials have said, well, we've clearly made mistakes and we need to pull back on some aspects of NSA surveillance. I think that when you have public discussion of legal positions or policy positions that have been taken within inside the government, you have a different kind of discussion and a more careful kind of discussion. And it's inevitable that when you have deliberations that are limited to inside the government, that are not being made public, you won't have discussions that are as careful and painstaking as the discussions you have when things are reported and people who are outside the loop are suddenly brought into the loop and are allowed to make their own assessment of the judgments that government officials have made.
I agree with you, that's a step forward, but it's still, it's just shocking to me that they want to have the discussion. I understood that they wanted
Yeah.
to hide from us that they were doing it, but now that they're just coming out and saying, listen, we're going to start prosecuting using illegal, warrantless wiretapping. There's going to
Yeah.
dragnet surveil and use it as needed. I mean,
No, I
that's like so
agree.
shocking. I mean, this is the government. What the heck is going on? Is that shocking to you, or is it?
I would say the extent of the surveillance was shocking to me. I was surprised by some of the revelations that came out after when I was surprised at some of the stuff that Snowden revealed. I would have expected that there was a great deal of surveillance there. It was more extensive than I would have imagined, and more cavalier than I would have expected.
On the numbers and the 100,000 versus the million, I took you to be estimating how many Americans were being tapped. And my impression was that the numbers were numbers globally, since the British and the French and the Germans are being tapped in huge numbers. Yeah.
I wanted to ask about an aspect of transparency that we touched on, but you didn't quite address directly, and it's in contracting. That because this is secret and involves intelligence, is there a sense of the scale of how much money is involved and who that money goes to? That because the contracting is not done publicly, we've already seen just from semi-public military contracting, we see $500 hammers and $20 ice cream cones and things like that to supply our troops. Well, who knows whether any of the exabytes in the facility in Salt Lake City are being gotten at reasonable prices or efficient. And who's making the money, and what kind of legal recourse do we have to be able to tell that people who wanted the opportunity to compete for this had the opportunity to compete for this? My recollection is here on campus when Clinton's FCC and economics cabinet people came here and spoke at the business school in advance of the 1996 Telecommunications Act, and the reaction of most of the faculty and MBAs at the time in the business school was they all raised their hands and said, how can we get in on this scam? That, well, isn't having intelligence services contracting sort of a scam in that sense?
I would say that it's fertile ground for scams. Government contracting has long been it's long been a site of fraud and abuse, and it's a process that needs to be policed, and it's hard to police it when we don't know what's going on. So there's certainly lots of outsourcing of lots of surveillance activity. And you're right that we don't know a lot about the ways in which those contracts are awarded, or the steps that are taken in order to police the contractors, because we don't know a lot about the programs at all.
So where is the money?
People might be the same people that are getting contracted out to do the spying. Is there any connections with the privatized, corporatized prisons that are getting set up? Because that seems like kind of a nightmare scenario when they start, when the spying and the prisons start linking up with the DEA, and it's all profitized, put away as many people as they can. That's what's concerning me. Do we know if there's any connection between spying and corporate prisons?
Well, I don't know about the corporate prisons. We do know that the DEA has been very eager to get hold of the NSA information, and this is another reason to be very worried that once the information exists and collected, every law enforcement agency has an interest in accessing that data, and so
Yeah.
Take that money when they get you put away.
I'll say that.
Wasn't your article about the DEA?
That was the Department of Justice that made, well, they may have given, I forgot what the prosecution was about. It may have been a drug thing, I can't remember, but it was the Department of Justice that said they intend to start using warrantless wiretaps. Thank you for alerting us, but they're alerting us.
For probable cause, not for
so we have some.
It was a warrantless, it's a dragnet surveillance, and then they later decide, now we're looking at you, so we'll go ahead and use that warrantless, illegal The Department of Justice. It's the New York Times, October 26th. Look it up. Department of Justice, warrantless they're going to start using warrantless wiretapping.
So the magic microphone has been passed.
Yeah, one question I have is that the reasonable expectation of privacy, I think, was the key phrase I remember years ago from law school with the Fourth Amendment and the Cass decision. And that was supposed to be the basis of everything from, the classic cases would be about someone growing marijuana on their property and the police couldn't cross the curtilage or the fence in front of the property, otherwise if they could see it from the street. There was another case at Kylo about the infrared, or whatever it was, that they couldn't focus a heat source and notice your heat lamps out of your house. I mean, that was another limit that was kind of this pre-September 11th era. And another one was if you could fly over, if the police could see, say, your marijuana growing in the backyard from an airplane, that was fine, but it couldn't be, the airplane couldn't be too low or whatever you had. Otherwise, that was not permissible, kind of like crossing the curtilage. So, I mean, that entire world was out there, and now, September 11th and drones and surveillance have kind of turned that all on its head. So that was one point that I'd like to hear a little bit first. My first kind of question is about where does this reasonable expectation of privacy stand today, and could it be that in the last, since September 11th, has this objective, reasonable person's view of the world changed? And I don't know if it will be affecting more of jurors. That's why I'm kind of wondering. So my first thing, and I'll probably follow up with something else, but I want to know about where does this reasonable expectation of privacy standard stand today, or is it still good law?
So it's still good law. It has always been the subject of criticism because it has seemed to many people vague and also circular. Circular because it asks whether a reasonable person would expect privacy, and the one problem is, well, if a reasonable person lives in a society where a certain kind of privacy isn't respected, then that person, if he or she is reasonable, won't expect it. So there's always been a worry that the standard is subject to manipulation and isn't protective enough, but it is still the standard. There have been aspects of the Fourth Amendment that have been weakened since September 11th, apparently because of concerns about terrorism, but I don't think this is one of them. I think there have been two developments in the way people think about the reasonable expectation of privacy, I would say. So one is that as surveillance has grown more common, it's become less clear what kind of privacy a reasonable person would expect. And the other is that as the government has developed the ability to collect and rapidly analyze records of surveillance, invasions of privacy that used to strike the Supreme Court as not a problem because they don't infringe on reasonable expectations of privacy, have now begun to seem to many people, including members of the Supreme Court, as something that deserves to be worried about. And so let me just say a little bit more about that. So there's long been an idea that the Constitution doesn't protect your privacy when you're out in public. And the thinking was that a reasonable person doesn't expect privacy when she's walking down the street because she knows people can see her walking down the street. So if the police follow you while you're out in public, there's long been an idea that that doesn't violate your reasonable expectation of privacy, so the Fourth Amendment doesn't even kick in at all. There's no constitutional restriction. And because we've tended to, in this country, to think that the police should be regulated chiefly by the Constitution, the fact that the Constitution doesn't kick in has meant, by and large, that there's no legal regulation of how the police monitor you when you're out in public. So now technology has advanced to the point where, with not very great expenditure of resources, the police or the intelligence agencies have the ability to track somebody's movements in public over an extended period of time. And it seems to lots of people that tracking somebody's movements over, say, 3 months and knowing everywhere they go over 3 months is different than just watching them when they're out for a walk 1 day or 2 days in a row. It seems that way even, I think, to a majority of members of the Supreme Court. So they don't yet know what they're going to do about that. But they've sent signals that they're worried about it and that they may need to rethink the circumstances in which surveillance of things that people are doing in public counts as an infringement of a reasonable expectation of privacy. With regard to the NSA surveillance, though, it's pretty clear that virtually all of the contents of email messages and telephone communications are protected by a reasonable expectation of privacy. So if the NSA is listening to the contents of telephone communications, if they're listening, they're reading what you say in an email, it's clear that that violates a reasonable expectation of privacy. And I don't think anyone, well, I don't know because it's secret, but my guess is that not even in the secret documents has somebody suggested that that doesn't violate a reasonable expectation of privacy. There's a difficulty, though, with respect to what sometimes is called metadata or package data. That's the telephone number you dial, the number you're dialing from, the email address you send something to, your email address, the time and date of the email, any of that information. And the difficulty is that the Supreme Court decided decades ago that the telephone numbers you dial and the telephone numbers from which calls are dialed to your number are not protected by any reasonable expectation of privacy. And that was a decision made well before there was email. But the rationale became woven into the fabric of American law so that it's widely assumed by Congress, by state legislators, that that information is something for which no warrant is necessary, and something for which access should be granted pretty liberally to police agencies and intelligence agencies.
One thing,
Go ahead.
David, I'm wondering what your thoughts are about this. One thing I've been struck by is that Americans are much more tolerant of corporate intrusions into privacy or corporate use of personal information than they have been historically of governmental use. And so, if you use Gmail, you're used to computers scanning your email for signals that you might be interested in getting a degree or, making a movie or buying furniture or something like that. We're used to that kind of computer scanning. And it would seem plausible for a government lawyer to argue that that affects the reasonable expectation of privacy, and therefore the government ought to be entitled to the same sort of automated scanning, content-based scanning, since we tolerate it, we accept it as part of our Gmail contract or terms of service. And yet, as I say, there's been this an attitude of an asymmetry. It's different when, when Google does it than when the state does it. And
I'm not sure because, as you pointed out earlier, there was a kind of collective national shrug about Snowden's revelations. I think that there, when people.
Snowden is 70% popular among the ages 18 to 35. You know that?
I didn't know that. No.
But the polls about people,
Yeah.
no, it's not cutting him down. It's just saying
Yeah.
the polling of people about whether they're outraged by the amount of snooping the NSA has done doesn't show a very high level of outrage.
I think that information collection, lots of kinds of information collection become accepted once people get used to them. I think, And it happened when I remember when Gmail was first announced, there were a lot of people who said this would be terrible. I would never agree to send email knowing that a computer is scanning it to see which kind of ads they'll direct to me. And lots of those people now have Gmail. When cities and counties began to construct surveillance cameras in public to monitor downtown shopping districts or to catch people who ran red lights, there was a lot of controversy about it. But now it's become completely accepted. I would say in the aftermath of the Boston Marathon bombing, I didn't read anything that suggested that anybody was either surprised or dismayed that the government was quickly able to retrieve photographs of the suspected bombers walking down the sidewalk. We've grown used to that.
And so it's interesting you bring up issues about social media, and what we have today, what we didn't have, say, 20 years ago, is that now people voluntarily place things online on Facebook, and it's my understanding if you like a business on Facebook, I might be wrong about this, that they somehow get access to some of the information on your page. I might be wrong about that, but it just seems that you think it might be private with a group of friends, but people are posting things up there that they wouldn't have before, and perhaps it might even be sold by Facebook to other organizations and perhaps even fronts for governments. But the question I had, my second question, and I'll pass over the microphone after this, has to deal, and this might be more of a Professor Kutz type of a line I'm looking at, is that I'm thinking again before September 11th, there were a whole other standards of Supreme Court cases about the Fourth Amendment, about at the international border. So this gets to be the foreign versus domestic. I spoke earlier about domestic, about someone in their home. No, the foreign, I think even the FISA court has foreign in its name. I might be wrong about that. But so the entire issue with that, I think in the old days, say in the 1960s, the federal government could open your mail at the borders, I guess, to check for customs things, to see the contents. I don't know if it could look at the content. I think it could somehow record the names and addresses. So it'd be interesting to find. But anyway, when you're at the border, I don't know if, well, actually they could, because they could review things that were obscene inside of it. So there may be some standards out there that allow. And that's why I think one of the issue with Snowden's revelations was that if there was one side of the conversation that was foreign, that using those old kind of line of cases about being able to inspect things at the border allowed the government more access. So what I'm going at now with this is, who is to say that and again, this is kind of hypothetical, but could be happening. Your email that could be completely domestic between two, right here on campus, or maybe that's a bad example, but here in San Francisco, was to say that there couldn't be some routing of it that would route it out of the country and route it back into the country, and maybe they could check with the ISPs to see that. So that's one way I think they can get around it. And the other thing I really wanted to find out is we have this idea of the extraordinary renditions back of where we actually have, we raised due process things in the Constitution, where we'd have a third-party country, just to say some other third country was involved with questioning our suspects, perhaps torturing them. Well, could we also have an extraordinary rendition type of issue with domestic email where we turn our back on it and there's somehow some deal is worked out where our email just between here within California is routed out of the country, routed to a third country, and they go through it, and then they have a deal where they kind of share the information with, and I mean, the other issue is the information sharing that goes on. That's why some people say when Angela Merkel was outraged that her phone was being monitored, that other people said, well, a lot of these European countries are benefiting from the surveillance sharing. So I was thinking that entire issue, like legal standards for that, of having where your email or whatever is, the functional equivalent would be your letter that you'd mail across the street was being sent out of the country by the Postal Service so they could inspect the contents of your letter. That wouldn't have been permitted 50 years ago, but now, at a flash of an instant, you can route email all around the world. So,
I think that was the comment of this gentleman here. I mean, that's the GCHQ workaround, and I think all of the intelligence agencies in the world are eager to exploit the limits of law, the bordered limits of law, to work around those borders. And yeah, the NSA is ahead of you there.
But is there any legal standard right now that prevents it from happening?
I think no. It would have to be a memorandum of understanding among the intelligence agencies to decline to do that. That seems unlikely. But there's no. I mean, one could imagine an international treaty to try to restrain the use of data. It's hard to imagine a legal proceeding under the Universal Charter, or the ICCPR. But I suppose one could imagine the case being litigated litigated in one of the regional courts as well.
Look, if the Berkeley Police Department wanted to search my suitcase or my briefcase, and so they grabbed it and they drove it to the Mexican border and gave it to the Mexican police and said, please look, open this up and then give it back to us. And then the Mexican police looked through it and they gave it back to the Berkeley police, and the Berkeley police drove it back to Berkeley. I'm positive that I could challenge that successfully. But I wouldn't be at all surprised if inside memoranda that have not been made public, someone has argued, some government official has argued that that's a sensible way to think about how we should handle email communications. It's an example of the kind of argument that when you're in an echo chamber might make sense, but if you have the kind of transparency that you should have, would be exposed as silly.
I'd like to ask, how many have seen the movie Dirty Wars? Just me, yeah, okay. So I think we're kind of done with this topic in terms of the drone, switching over to the drones, killing a 16-year-old American citizen, something clearly illegal. There's no pussyfooting possible with something like that, I think. The other question I'd like to ask everybody is, does power corrupt? Okay, so me and the founding fathers believed power corrupts. Now we have an electorate that doesn't believe that power corrupts. So when they get corrupted, they're constantly surprised, and I don't know what to do. I don't know what to do, So it's like, how do we get from here back to realizing that power corrupts? I think Europeans kind of know that, and people in other countries know, that power corrupts. Why have we lost that? And the other question is, who believes in checks and balances? Okay, well, I thought checks and balances was one of the three parts of the government was the courts, and maybe our responsibility is to sue the government. And Ralph Nader's been sidelined to the point where you ask a young person, who's Ralph Nader? Oh, he's the guy who tipped the election from Gore to Bush. Nader caused the Iraq War.
Well, the revelations today, for example, of the MSA exceeding its limits under the 2009 court order that it had, come from a suit filed by the ACLU against the government demanding the disclosure of this information. I think the path of citizen, interest group litigation is so far, apart from Snowden, been the only path forward towards transparency, and it is, it's doing some work there. I think you're right. I mean, again, the example, the Senate Intelligence Committee is not an effective check on the intelligence services. They're co-opted by the intelligence services. The FISA court is not an effective check on the intelligence services. I think citizen action seems to be the only check left. There was a question over here I saw.
I'm talking about, this room is representative. I know how to sue the government. I moved to Berkeley 2.5 years ago saying, who wants to join me? And I've been announcing it to hundreds of people, and no one is interested at all. It's just like I can't get them to push a button to help me, So, we can point the finger at the people in power so long before, it's time to point the finger at ourselves, And my other comment is, one microphone, trying to call this a conversation with one microphone is ridiculous. It's not a conversation, it's a lecture, most of it.
that was my fault, I guess.
You love me for the food. You were busy, though.
Okay, so one of the comments I often hear is there's a difference between the value of life of someone in Pakistan versus someone who's a citizen. And that always really gets me, the morality, the ethics of it. How is it that 3,000 people in Pakistan can get killed? And it gets a bit of attention here, but then one American citizen is, and everybody's now talking about it, it's illegal, where's the morality and ethics in our legal system these days?
I agree with you 110%. I think it's a mistake to focus on, except strategically perhaps, on the cases of the Americans killed without constitutional protections. It's not, the morality of this is independent of what the 14th Amendment grants to particular Americans who happen to be located in particular places. The 16-year-old American who's killed accidentally is morally no better and no worse than the 16-year-old Pakistani who's killed accidentally. And I agree with you that each of those deaths is tragic and should be weighed equally and should be taken as seriously. It's a feature of our legal system that American citizenship confers certain procedural rights that appear nonetheless to be very limited by the Justice Department. And so there's a strategic reason why, for example, the ACLU has been acting through the channels of challenging the killings of Americans this way, because there's more to work with than the killings of foreigners. But as a moral matter, I think you're absolutely right. I don't have anything more to say than that.
In line with that, one of the problems is that the Pakistani government, parts of it are actually complicit. Sorry.
Right, the Pakistani government has been doing deals with the CIA. If you kill our people, we'll let you kill your people.
Because what happens is there are deals being done with segments of the security services where there's no secret, actually, in certain branches of it, that they don't mind seeing drone strikes being used, because that way they don't have Pakistani personnel doing the stuff.
Yeah.
So the sad reality of it is that someone like, for example, the former illustrious cricketer Imran Khan, part of his group, he might be protesting against the use of drones, but even as he's doing that, and even as Nawaz Sharif is in Washington actually making that point, there is also an understanding and this double take on it that these drones are also being used with complicity in the Swat Valley. That's the tragedy about that, actually, that there is this very dark understanding about those operations.
Anyone else?
If all the stress caused by drones flying overhead created all those people to go to psychiatrists at San Francisco rates, the cost would be trillions, the war would end. And if you look at the news of why the Iraq war ended and why the Afghans is in negotiation for ending right now with total troop withdrawals, the answer is civil and criminal. The Afghans and the Iraqis wanted civil and criminal law, and Obama didn't give it to them. He turned tail and ran. When it came to lawsuits, he says, no, wrongful death suits on all those. He left Iraq, he left Iran.
I'm not sure I agree with that diagnosis, but it's interesting. Yeah.
Democracy now.
Yeah.
Quick question. What are your thoughts as far as, they just authorized, FAA just gave 7,000 permits for drones, I think are going up either this year or may all be hitting in 2015. I'm not sure if you know if it's 14 or 15, but by 2015, they're estimating over 25,000 drones will be aloft. And I want to just get you to get out your crystal ball. Fast forward 10 years for me with your crystal ball and tell me what the likelihood is you think that they won't be using lethal force. There's a lot of terrorists, as you know. There's so many terrorists everywhere. Do you think we'll be seeing armed drones in the next 10 or 15 years in America? Or I should say with lethal weapons.
I don't have a prediction. I think there will be enormous pressures towards arming drones, and I think were you the one you sir were the one who said that the story will come out first as firefighting or something like that. That first it'll be water cannons and then it'll just be cannons. There is movement in that direction. There's interest. I think not just aerial drones, but armed robots are, there's been a lot of experimentation with that in the military. Entering a building with an armed device is very attractive for the military. It's equally attractive for a SWAT team or a police department. So I think what I can't predict is how extensively they'll be used, but I'm certain that there will be remotely operated armed platforms deployed by police in the next 10 years.
With lethal force.
With lethal force, yes.
And the check will be civil suits against.
Doesn't seem to be doing too much. If you look at YouTube, just type in U.S. police brutality, over 500,000 results that are on film. Doesn't seem how many lawsuits. They seem to be on a mission.
This is the argument for drones in combat, is that a drone operator is less likely to make mistakes, get overexcited, succumb to the fog of war than a soldier in place being sent into that situation. There are a lot of psychological reasons to think that's true. What is, I think, the offsetting consideration is that you're much more likely to send in an armed drone than you are a soldier in the first place. And so you may get more deaths as a result. But again, the police argument would be the same, that a cool drone operator, remote platform operator, is less likely to shoot the child in the closet than the SWAT team member in his gas mask, overheated, struggling, having just walked up 10 flights of stairs. And the question is, though, will there be an increased likelihood of trying to use force of any kind given armed drones? And I think the answer is yes.
I'd like to focus, as we're getting near our end here, about solutions. What you say, Professor Sklansky, that transparency seems like it's one of the solutions. I'd like to hear a little bit more about that. It sounds like the checks and balances. One issue I'm trying to think of is the FISA opinions obviously have been archived, but I'm hopeful that someday in the future all of this is being preserved, that we'll all be able to look at all this sooner rather than later, but that's probably a later, well, actually, opinions might be an early phase of it, being redacted, but I'm just trying to figure out, so transparency is one of your possible solutions, and I don't know, Professor Kutz, if you have anything of where we go forward, what can citizens do? That's what my concern right now, what can we do to go forward from today with this information?
Well, I do think that transparency is the best and most powerful lever that we can pull, partly because just as secrecy breeds secrecy, transparency can fuel more transparency. Once you know a little, that can help you in arguing that you need to know more, and it can tell you where you should be looking for more and what you should be looking for. So I think, as I mentioned before, that the legislation that Representative Wyden has introduced is hugely important, and I'm very much in favor of it. I think even the disclosure, even to the intelligence committees and the armed services committees, is better than no disclosure. But I agree with Chris that what really moves things is public disclosure, and the internet is a great engine for dissemination of ideas and opinions, and if we can get the information out of the government, where the internet gives us a lot of tools to make effective use of it, but we need to get the information in the first place, and I think, as I said, I think we have an administration headed by someone who I think has some good instincts about the benefits of transparency, but he's heading a very large organization with enormous amounts of institutional inertia, and it's very difficult to argue inside of that organization for ways of thinking that depart from the traditional ways of thinking.
What's the first thing you want to make transparent?
I would say the dimensions and nature of, I'm going to give you three. The dimensions and nature of the surveillance activities being carried out by the government, the dimensions and nature of our drone operations, and the legal rationales that are being relied upon in both those arenas.
I would just add, obviously, I think that's an excellent start. I think we need very specific controls on the intelligence agency collection process that aren't in place now. We need the transparency to make those controls effective, but we need much stricter limits on who has access to the information. We need enforcement of the limits of how that information is collected. We need separation between those who have sort of the physical access to the information and the procedures of authorization. So one problem has been that it's too easy for the 24-year-old at his keyboard to ineffectively self-authorize access to unlimited amounts of information. And so some of that is a question of physical engineering, electronic, segregation of access. Some of it is a matter of legal engineering. The one thing that gives me some hope, one thing we didn't touch on, but is corporate activism. And one of the things that clearly has the administration scared is the anger by Google, Yahoo, et cetera, anger triggered by, say, the reaction of Brazil to say, we're going to insource all of our broadband. It's not going to go through your servers. But the corporate fear of losing out on the global market of information services seems to be pushing the administration harder than, well, the fairly non-existent citizen outrage and the fairly lonely battle that Ron Wyden is pushing. And that, so there's some reason for hope that corporate power will have some positive effect here.
Well, you refer to restricting access, I guess, within the government where they share it. But it's interesting, one of the reasons why Mr. Snowden and maybe Mr. Manning had access to all this information to begin with was the concern of the pre-September 11th world, the lack of access to the information, the inability to connect dots. But perhaps you're saying that there ought to be a more organized way of perhaps doing it.
There was clear, I think one general lesson we can take from 9/12 is that 9/12 was a vast overreaction to 9/11, and the under-securing of access to airplanes has led to the gross over-securing of access to airplanes. And so, but I think that, a similar lesson we could apply to sharing of information among agencies. It was too stovepiped, but now it's perhaps too promiscuous.
And also, I wanted to follow up, you said about getting corporate activism, because I'm wondering whether 50 years from now, for example, we're going to find out whether the surveillance industry here of Silicon Valley, whether they were benefiting from all this in some way or not. We just don't know about that today, but it would be interesting. But you're saying there could be responsible corporate activism could be very key to this.
Well, it's self-interested, but it may align with the citizen interest. I think another possible solution is the private development of encryption technologies that are effectively unbreakable by the government. And there's a struggle right now between government. Just heard this morning on the radio. There was a very interesting report about the proposal for rules to force the NSA to disclose to technology companies vulnerabilities that they find in their system. They're not currently required to disclose these vulnerabilities precisely because they want to exploit them for intelligence gathering purposes. So we have an adversarial system right now between American technology companies and the government, and perhaps some more adversarialism will be a good thing. It will benefit private citizens.
Sorry, one little bit. But you're saying there should be some type of line there, because obviously we want certain things for national security, and it's difficult to say how much that line should be for national security versus the disclosure and all that. That's almost a debate for another day, I think.
No, you're right about the trade-off there.
Yeah, one more comment?
No, as I listen to you, and you're awesome. I see a future with a complete loss of privacy, where everything we do and say could be made public, the way we're headed. I don't know. I personally think we need some sort of a revolution to stop all this. Maybe you could comment.
Yeah, I wanted to just add on to what you said about whether corporations were benefiting from this. And something I've been feeling lately is that it seems like corporations and the state are merging, and that, Mark Zuckerberg says, oh, I didn't, I knew about the surveillance, I knew it was going on, but I didn't say anything. But at the time, has deals with the government. Like 4 of Google's top executives have worked for the military and the CIA in the past. And the CIA recruits Berkeley students at EECS fairs like any other corporation. And so I read in the news that their engineers, scientists, and policymakers are working together to create autonomous drones with artificial intelligence. And I wonder where do they find the software engineers to do that? And so one thing I think that is helpful is we can only do so much about what's going on in Washington, but I think we can also look what's going on at Berkeley. What is the relationship? What is the CIA doing here? How are they trying to benefit from their relationship with the university? And I think one place in particular we can look at is the regents, because at least one of our current regents has business ties with the Carlyle Group, which is the private equity firm that owns Booz Allen Hamilton, which is the security contractor Edward Snowden was working for. And so I think if we need to be putting pressure on our governors, we can be looking at who are the governors here who are making the decisions that lead the university to support the national security state rather than oppose it. That's my thoughts.
You can teach a class on how to sue the government. I'm guessing there isn't one.
Okay, I think if there are no other comments, I would like to thank the professors for
Thank you
coming
all.
here and sharing their thoughts with us. Thank you.
Thank you.
Thank you all for coming.